Well, good afternoon, everyone. Today is Thursday, March 24th. Welcome to the Judicial Proceedings Committee. Today we have 7 bill hearings, all House bills, all sponsor only, I believe. The order for today is House Bill 639, Chair Atterbury. Excuse me, House Bill 71, Delegate Stewart. House Bill 404 and 713, Delegate Lehman. House Bill 1066, Delegate Stein. House Bill 1323, Delegate Bartlett. And House Bill 877. Just for the record here, we do have a number, just as we have a number of delegates here joining us in the Senate, so too do we have a number of members of our committee who are with the House of Delegates now, and so everyone is at work in other committees. Now we'll go to House Bill 639. Chair Atterbury, thank you for joining us.
Thank you, Mr. Chair, members of the committee. For the record, I'm Delegate Vanessa Atterbury here on House Bill 639. Some of you, I will say this committee passed this bill in a different form last session. During the interim, myself and Senator Lee participated on a work group along with Delegate Crutchfield with the family law section of the Bar Association and some other interested parties and actually a magistrate. And this was the product that we came up with. And essentially it changes how one can get divorced here in the state of Maryland and just simply streamlines it. So what I'll do is just walk through it. Instead of all of the laundry list of reasons that one has to allege to get divorced, you have to allege that the marriage has, there are irreconcilable differences in your complaint. And there are 31 other states that use some language like that, irretrievably broken. The group decided to go with irreconcilable differences. There has to be a 6-month separation. As well. Now, I do want to state that the grounds that we are all familiar with can still be used when it comes to division of property, custody, and the like. But just in terms of filing for divorce and moving forward, you can allege irreconcilable differences. The other change, which is the part that this committee passed last year but didn't make it through on sine die, was that parties can reside under the same roof if they have pursued separate lives and can be deemed to have lived separate and apart, then they too can file for divorce, which is what some other states do. And that is critically important when we're talking about folks that don't have the means to create 2 separate households, when there are domestic violence situations. And so we thought that was important too. With that said, I would ask for your favorable report on House Bill 639. I'm happy to take any questions. And there are other folks here who are experts in this that are happy to answer questions as well.
Thank you, Madam Chair. Senator Casserly.
It's good to see you, Delegate Atterbury. So these 1, 2, and 3, are those are or, right? These are 3 different grounds?
Where are you looking?
I'm sorry,
Senator?
on page 3,
Okay.
line 17 of the bill. And it says 1, 6-month separation, 2 irreconcilable differences. These are alternates, so this would be number 1 or number 2 or number 3, right?
The 6-month separation is required.
Okay.
No, it's or, you're right, it's or.
Gotcha, okay. I'm just trying to piece it all together. And then on page 4, why do we delete line 22 on page 4, the condemnation language?
Let me find it really quickly here.
Is that because adultery is no longer a ground for divorce? Is that how that works?
Do you mind if I have one of my experts answer?
Sure, no, yeah, I can get one of them when they come up.
Okay. I have it right here too. Yes, please. Committee, this is Michelle Smith. She co-chairs the Family Law section of the Bar Association, who overwhelmingly supports this legislation.
And Senator Casserly, could you please
on
repeat your question?
Sure, page 4 of the bill. And then we delete lines 22 through 30.
And that says.
Condemnation is not an absolute bar.
Okay, I'm looking at a different line for what the language that you're pointing to. Mine says 17 through 19. So we deleted all of the language that related to the adultery. So condemnation would have previously related to adultery under the current grounds, and those grounds are no longer in place in this statute.
So you couldn't get, is there an immediate divorce? Can you file an immediate divorce, or you have to wait 6 months separation?
No, you can file for an absolute divorce based on irreconcilable differences or mutual consent, or if one party is not, has lost the legal capacity to make decisions, or a 6-month separation.
So we're sort of shoehorning in adultery into one of those three categories?
I'm not sure I understand your question.
Yeah,
Could you
we're
say it
taking
a different way?
adultery is out completely. We're taking out adultery and desertion. Those come out, and we're just going with either a 6-month separation or irreconcilable differences or permanent legal incapacity.
Or mutual consent. Yes, that's
mutual
correct.
consent.
So adultery would still be, you could allege it as a fact that led to the irreconcilable differences. And so the facts of the adultery could still be placed in front of the court, either in your complaint or in a hearing or a trial on different issues like alimony, custody, monetary awards. So it's not that adultery would no longer be relevant, it's just that it's not required as a grounds to get you into the courthouse to file for divorce.
Okay, and irreconcilable differences sounds like as long as the parties believe that whatever their differences are, whatever they might be, even if they were slight, that those differences are irreconcilable and would justify a divorce, right?
Well, it would be up to the finder of fact, the judge, to grant the divorce based on the facts presented.
No, I got that. That hasn't changed, but we say it's irreconcilable differences. So we know that doesn't change. There's a standard. Irreconcilable means we just can't get over it, right? But differences, it's not defined in the statute anywhere.
That's
so
correct.
Differences can mean something as minor as he likes to eat crabs, I can't stand all the crabs, that's a difference, and that's irreconcilable. Well, all the way up to he won't stop sleeping with other women, and this keeps happening, and that kind of difference. So anything in between, right?
Well, anything in between could get that complainant into the courthouse door, but it wouldn't, I don't think the crab analogy would get that complainant very far.
Why, though, if it's a difference? I mean, I'm just looking at what's the standard.
Sure.
One judge might say, that's your difference, that's your difference. You know, who am I to judge whether that's a significant difference? I mean, because it doesn't say a significant, it just says differences.
Well, it says for the permanent termination of the marriage.
Right.
So in order to permanently terminate a marriage, a finder of fact would have to decide that he likes crabs and I don't is enough. And I we've talked about these particular facts, circumstances. I don't believe that that's going to be enough unless there's something else in addition.
But it's up to the judge. If an individual judge could say, in my opinion, I hate the smell of crabs, so that's good enough for me.
And that would have to be after listening to the opposing party and what they had to say. So if the opposing party comes in and says, this is the first I'm hearing about any differences whatsoever, that difference seems to be de minimis, and there are no other witnesses supporting that our marriage should be terminated. We've been married for a long time. This seems outrageous, or a ploy, or something nefarious is going on. I think the judge might be hard-pressed to make that decision to grant a divorce based on those facts.
Okay, but it's funny, it is sort of a subjective standard based upon who the judge is. I mean, some judges may say, you may have a case where the parties truly believe that this is not just not eating crabs, but something they find much more substantial, and a judge could say, it's not good enough, right?
Mm-hmm. And that's the state of our law right now. The judge gets to decide.
Well, not necessarily. The state of the law says if you cheat on somebody, if you find that there was cheating, boom, you're out. If you separated for a certain period of time, you're done. If you voluntary, you're done.
Mm-hmm.
But there's a pretty, cruel and unusual all those sort of things are pretty set in the law. But this is a pretty malleable standard, it looks like.
So irreconcilable differences has not been defined in Maryland yet because we haven't passed this bill yet. Once we do, there will be some appellate case law. I have no doubt about that. But
Yeah.
there is case law in other states for us to look to and for the appellate courts to look to,
Yeah. It
which
just seems like
define that.
we're punting public policy to the brilliant sages at the other end of Roe Boulevard, which always scares the heck out of me, but, okay, thank you very much.
You're welcome.
Thank you, Senator Cassidy. Senator Lee.
Thank you, Delegate Atterbury, Chair Atterbury, and also the individuals that are here today for this bill. I know that considerable work went into this, and we didn't take it on the fly. We really worked hard on this. Wouldn't this benefit a lot of individuals, particularly those with children, and particularly when we have a housing crisis and also we're during a pandemic?
I agree with you wholeheartedly. This would help individuals who are stuck in the same household and who can't get out of the same household but who need to separate. It would help individuals who are living in the same house in a volatile situation and that have children, and that volatility obviously would stem down to the kids and it would allow them to separate. So I agree with you, and thank you for your participation on the work group.
Senator West.
Thank you, Mr. Chair. So I'm also interested in this term irreconcilable differences. The good thing about this bill is it provides that if the parties live apart for 6 months, you don't need irreconcilable differences. You can get a divorce. But I do have a question about what the word means. It's not defined, and you indicated that the courts would have to come up with interpretations of the word in order to define it. Let me just give you a hypothetical. The wife has an adulterous affair. The husband decides he doesn't want to be married. It's irreconcilable. He's not willing to be reconciled. The wife says, but I made a mistake. I still love my husband. I don't want to be divorced. As far as I'm concerned, I'm happy to work it out. How would the courts handle that situation where one of the spouses, there's a classic situation which would have qualified the parties for a divorce. One of the parties says, that has occurred, I will never be reconciled. The other party says, I want to be reconciled because I still love my spouse. How the court's going to handle that? Do we have any clue?
Senator West, we do have a clue because that does happen now.
A lot, I would think.
Yes, and the judges have to make the decision as to whether to grant the divorce or not, even over the objection of the other person. So the current status of our law has dealt with those issues and will continue to, whether it's this bill or some other version of this bill or the current law. One thing I want to point out, and I think that you just said it so perfectly, even in that circumstance, the party who wants the divorce under this bill
After 6 months, gets it.
just has to wait 6 months.
Right. And in fact,
That's
it might take almost that long to get into court.
It would take that long to wind through the court system,
Yeah.
definitely. What we're trying to do with this bill is to prevent it from taking that long to get into court.
Okay.
So this gives more people access to the court in a manner that they can understand and they can get going on the case. And then the judges will decide how to work out the differences like the one that you've just brought up.
Okay, and if the parties get into court and the 6 months runs while they're in court, I assume
Yes.
the complaining party, the plaintiff, would be able to amend the complaint
Yes.
to add a second count that the 6 months is run.
Yes, and in fact, the statute does provide for that, just
Okay.
like the current status of the law, where people can amend to a 12-month separation, even though they filed based on adultery or something along those lines.
Terrific. Thank you for your answers.
Thank you.
Senator Watson.
Yeah, so my question is this bill just more about speed and how quick you can get a divorce? I actually look at this and as the chair knows, I kind of look at it from a whole different lens. I would think that this just makes it so much easier to not really respect the importance of marriage when you go in, because it's now so easy to get out. And so I can understand shrinking it down for 6 months, but why? Why not keep it a year to give folks an opportunity if there is something other than irreconcilable differences, which we don't have a definition of, to work things out and to you know, try to work through these things. I mean, that's what I struggle with. We just, so easy to get married and then say, oh, I'm tired. We all agree? Okay, we're out.
And I'm going to comment, and then can Laura Ruth respond? Okay. Well, Senator Watson, one, it's good to see you. Two, you were across the street and you sat through some of these lengthy debates on these bills related to divorce. So I think that you would agree that this is actually not about speed, because if you remember our conversations over there, there were people who wanted in judiciary to get divorced by affidavit. I mean, there were people who wanted folks to immediately get divorced. And so I thought that the 6-month separation was a good compromise. 12 months, in my opinion, and the opinion of folks who came to testify before us, it's too long, particularly when you're in a volatile situation. It's too long to be in that situation just to be able to get into court to say that I want a divorce, to wait a whole year. And I think if you heard from Ms. Ruth, she would say that this legislation would give so many more people access right now who just don't have access because they're in the same house, they're unable to create 2 separate houses and live separate and apart for that extended period of time.
I didn't look at the list of folks testifying today. Are any men here to testify on behalf of this?
Well, this is sponsor only.
Sponsor only. On your side of the house, when you did it
We
on
did.
the House side, were there
We
any
had-
men who testified for it?
Yes,
There were?
we
Okay.
had one gentleman.
Thank you.
All right, back to Senator Castle.
It was it was a study group, right? Or I forget what you call it.
Like
commission?
an interim work group.
Work group. Did anybody consider 2 forms of marriage, marriage light and marriage heavy, something like that? I mean, look, if we're both 50, nobody's going to have any kids. Who really cares? Let's go. If we can, this will last for 6 months, 6 years, 60 years. It doesn't matter. But or a young woman who says, look, I've a fork in my life here. I can go into the mommy track and have 3 children, or I can go in and pursue my PhD and be a world famous surgeon and make hundreds of thousands of dollars a year. But based upon your promises to me to love, honor, cherish till death do us part, I'm going to hold you at that word. I'm going to go ahead. I'm going to have these children, and recognizing I've now probably cut my earning capacity substantially, made my life much more difficult, that maybe she would say, look, I want marriage heavy. If I'm going into this, I don't want, you're going to have to be, if we're going to split this thing up, it's not going to be easy. You're going to have to stick, it'll be at least a year of separation and all that. I mean, it seems like we're what Senator Watson was talking about,
So I have to apologize. I don't know what you mean by marriage heavy or marriage light.
well, marriage heavy would say, kind of retain more of the traditional, that we don't walk away too easily, that you're going to have to be separated for a year. You're going to have to prove adultery. And that would be for young women who really want to protect themselves, their interests, so that they want to basically tell their partner that I'm going to hold you to this because I'm changing my life radically based upon your promises till death do us part. And then other people would say, we're not ever having children. We're both professionals. We both already have our PhDs. We're both our earning capacity. We're going to come together and be married. And hey, if we split up, it doesn't really hurt anything anyway in either one of our lives. Was anything like that considered, that you'd actually have 2 forms of marriage?
We did not discuss marriage heavy or marriage light, to use your terminology. What we discussed was folks having access to the court system, and folks being able to have an opportunity to separate when they're in situations where they cannot live together, and it is emotionally harmful to them, to the children. That was really the focus of our discussions and the impetus for the bill, quite frankly.
Did anybody pursue Senator Watson's line of thought that hey, if we need people to stop and think really heavy before they go into this, that this is going to be tough to get out of, and so don't take this step lightly? Was there any thought given to that?
Well, I can't judge what people think when they enter into a marriage. I would hope that most people enter into a marriage thinking that they're going to be in it long-term, and perhaps it becomes a situation for whatever reason that they can't tolerate anymore. Perhaps they didn't know somebody was going to be
But
emotionally
that wasn't
abusive.
discussed. This issue wasn't brought up in the work group. They didn't discuss his point.
His point was about making it easier to get divorced. That was brought up. That is not the purpose of this bill.
No, his other point was that people, if it's tougher to get divorced, people will take it more seriously and will take marriage more seriously. Was that brought up at all?
I disagree. I don't think that was his point.
Okay, all right. Thank you.
Apologize for being late, so I missed some of the context for this, but I do look forward to going through all of the testimony and rewinding to the recording of the hearing. But I would just like to ask the sponsor of the bill about whether the work group took into consideration men and women's ideas of marriage and what marriage is about, and whether you had any consideration of women in particular's professional goals and aspirations, and whether there was any accountability with regard to whether that was relevant to the conversation about how seriously women take marriage, and whether there was conversation about traditional marriage or not traditional marriage, and men and women's relationship in 2021 and 2022, and kind of what those professional aspirations bring to a marriage, and in the context of the discussion about how to end marriages. I would just like if you could shed a little light on that.
Thank you, Senator Heddleman. So to answer your question just directly, no. The work group was simply focused on what is our statute now. It was made up of a lot of practitioners who see all types of marriages, I would imagine. These folks practice family law day in and day out. The Women's Law Center gets hundreds and hundreds of calls. The House of Ruth gets hundreds of calls. So they have seen and heard it all. And so in the context of their professional experience, we focused on practically in what they do when they go to court. How can people get divorced? How can people safely get divorced? And how can people have access to the court system?
And do you have any idea whether women seek divorces more frequently than men, or whether there is roughly an equal?
I do not know. I think it is a leap to say that women are always the ones seeking the divorce.
I would agree with you. Thank you.
All right, further questions from the committee? Seeing none, thank you very much. Sorry I missed the testimony. Good to see you, Madam Chair.
You too. Thank
All right,
you.
good to see you. Thanks. And with that, that'll conclude the hearing for House Bill 639. We'll now move on to Delegate Stewart with House Bill 71. Welcome.
Thank you all. You'll have to be a little patient with me. This is my first in-person bill hearing in more than 2 years. So for the record, I'm Delegate Vaughn Stewart, and this is House Bill 71. The original version of this bill, it came in as it often happens. It came in a little bit more ambitious. The original version of the bill generated some opposition, but we worked with the opponents on some consensus amendments that are before you, and this bill ended up passing out of my committee in the House 24-1. So as amended, HB 71 requires the owners of manufactured and mobile home communities to give the residents of those communities a little bit more notice before they sell the property to a third party. Owners would have to notify residents of a possible sale 60 days before they enter into a binding contract. And we don't expect this to lengthen the sales process very much, if at all, because owners generally engage in a due diligence process of at least 60 days after they agree on the terms of principle for the sale of one of these communities and before they actually sign on the dotted line for a final contract. The reason this bill is important is because residents in these manufactured and mobile home communities are extremely vulnerable when the community owner sells the property. If the new community owner intends to raise the rent, then residents might be forced out that way. And if the new community owner wants to change the purpose of the property, like, for example, build condos or build an amusement park or what have you, then residents will definitely be forced out. And that's a big problem for folks who own their own mobile home, but they lease the land underneath it, because moving costs can be upwards of $20,000 or $30,000 to move one of these, manufactured mobile homes, and that's only if you can find a vacancy in a nearby community that you can actually move into. So what happens right now is that mobile homeowners, manufactured homeowners, they get 30 days notice before the sale is final. And that's basically less notice before a potential displacement than essentially any other Marylander gets in any type of housing. The eviction process, as this committee knows all too well, can take months to finalize. Homeowners get several months and several opportunities to avoid foreclosure. Even residents of homeless shelters get more than 30 days notice before they're asked to leave a homeless shelter. And so Maryland is the only state between South Carolina and Maine that affords so little notice time to residents of mobile home, manufactured home communities before a sale is done. The second part of the bill essentially gives the residents the opportunity to band together and submit a collective offer to purchase the property within that 60-day window, but they've got to jump through a bunch of hoops to do so. So the owners would have to create a community organization that comprises at least 51% of the lots in the community, and then the organization itself would have to vote unanimously to submit an offer. And to be clear, the community owner would not have to accept any offer. It's not like a right of first refusal. The only obligation for the community owner is to consider it, so basically just read it. So again, in conclusion, the bill no longer has any opposition. It's a common sense way to afford residents in these communities with a little bit more dignity and a little bit more respect, and I urge a favorable report.
Excellent. Thank you very much, Delegate Stewart. Questions from the committee? All right, we have one from Senator West.
Thank you, Mr. Chair. I wonder about this word unanimously on the top of page 10.
Yep.
Suppose a single member of the homeowner association says no.
Right.
They wouldn't be able to make the offer under the terms of this bill.
This is something that we grappled with in the House, and obviously the community organization itself only has to comprise 51% of the lots in the community. And then basically after talking with council, what we determined is that the organization could work out in their bylaws a scenario where it would happen where you have a few holdouts. In other words, if you've got, say, 60% of the community of the lot owners in the organization and you have a few holdouts, they could work it out in their bylaws that said, okay, well, if we've already got a certain percentage that have joined and you're holding this process up as just a single or 3 or 4 homeowners, we could actually have a process where we ask you to leave the organization because the goal here is to create unanimity and to put it in an offer. So we think that there's enough flexibility in the bill to work that out in the bylaw process for the organization.
Well, under normal circumstances, if the homeowners association, by whatever the bylaws provide, were to vote to do something, a single dissenter would not be able to stop the homeowners association from doing it.
Right.
Why is it thought to be important in this one situation?
Right.
That you can't have even one dissenter?
Yes, it's a great question. And the reason is we did not want to bind anyone to purchase a property that they don't want to purchase. That's the reason.
But it wouldn't be them, it'd be the homeowners association that's buying the property.
Right, but depending on whether or not that offer includes some sort of requirement that everyone would put in some sort of amount or an equal amount, then there would be a concern. There was a concern there with council that essentially people could be unwittingly bound, that they would have to put money up as being part of the homeowners association. So we wanted to provide essentially an opportunity where the bylaws could state if they don't want to provide any money or they don't think the deal should go through, they could have a path to the exits.
Right.
And join the sort of minority that is not joining the organization. And then the majority could therefore have that unanimity behind the offer.
See, thank you.
Yep.
Seeing none, thank you very much,
Thank
Delegate
you all.
Stewart. Thanks, good to see you. All right, next we'll have Delegate Lehman, you're up. It's House Bill 404, and then we'll take House Bill 713. Welcome.
Thank you, Mr. Chairman, and good afternoon, committee members. It's good to be back here. I think it's also been since probably 2019 that I was before this committee. So Chair Smith and Vice Chair Waldstreicher and esteemed committee members, for the record, I am Delegate Mary Lehman, and I'm here to ask for your favorable report of House Bill 404, authorizing local governments to lower maximum speed limits to 15 miles per hour on certain roadways after performing an engineering study. Pedestrian fatalities are on the rise nationwide, even with fewer cars on the road during COVID. And of course, the faster that vehicles travel, the greater the chance for fatal injuries to pedestrians, bicyclists, passengers, and drivers. The goal of HB 404 is to reduce injuries and fatalities and make Maryland roads safer by giving local jurisdictions the authority to lower speed limits to 15 miles per hour where that is warranted. This legislation is the statewide version of a bill that this committee approved last year. That was a Montgomery delegation bill. And it authorized Montgomery County only and its municipalities to decrease speed limits to not less than 15 miles per hour after conducting an engineering study. As amended in this committee, it prohibited the county from installing new speed cameras where the speed limit is reduced pursuant to the bill's authorization. Since Montgomery County is now authorized to lower speed limits to 15, other counties and Baltimore City, I believe, should have this same option. The state and many local governments have, of course, adopted Vision Zero policies to eliminate car-related deaths, and this bill, I think, would provide an important tool to assist Maryland in realizing that goal. Additionally, that traffic study, engineering study process I talked about will provide a great opportunity for citizen input in these decisions and allow them to voice their concerns. The House bill was amended, this bill was amended to clarify implementation of new speed monitoring systems in those areas where the speed limit is reduced. It is not meant to restrict. The way the amendment was written last year in this committee was a little bit awkward, and it sounded like it could eliminate the possibility of putting speed cameras in where the speed was reduced from, say, 55 to 45. So we talked to a couple of folks, including the bill drafter and Mako, and everyone agreed it was a little confusing. So we did tweak that. And again, in closing, HB 404 gives local jurisdictions to be at the forefront of ensuring traffic, pedestrian, and bicycle safety in their communities. It will save lives, and I urge your favorable consideration. Thank you.
All right, thank you very much. Questions from the committee? See, we've got one from Senator West.
I'm sorry. Thank you, Mr. Chair. I guess I'm confused by the bill. So if you do the traffic study, you're allowed to increase the limit in an urban district to not more than 50 miles an hour or decrease the limit in an urban district as low as you want. So you could take it down to 5 miles an hour.
No, so this is only around reducing speed limits. You might be looking at that confusing amendment language, which inadvertently read as if there could be no cameras in areas where the speed limit was reduced for any reason, say from 50 to 40 or 55 to 45.
Actually,
Are you looking at the amendment, Senator?
I'm on the top of page 2, lines 1 through 6. So it looks to me here as if they can decrease the limit in an urban district to an unlimited, to a really low rate. I mean, 1 mile an hour, theoretically, under subparagraph 3.
So that is the existing.
That's the existing law, okay.
That's existing law. We're not touching existing law.
Okay, so what are you doing then? You're taking
What
out the
we're
existing law
striking-
section that said you could decrease it to not less than 25 miles.
That was the current law, and it still is the law for the entire state of Maryland, except Montgomery, where the law was changed last year as a local bill for only Montgomery County. But that is striking the existing law saying that you cannot decrease a speed limit to less than 25 right now in all but Montgomery County. That is still the case.
Okay. All right,
Okay.
thank you very much.
Thank you for the question. I know it's a little confusing.
Thank you. Could you tell us what's happening in Montgomery County with their authorization from last year? I mean, any idea on how many streets have been reduced?
I do not recall, and I am, of course, on the Environment and Transportation Committee, so I do remember the Montgomery delegation bill. I believe it was the third effort to get that bill passed. It did pass. I don't believe, in fact, I'm almost certain the issue of speed cameras did not come up in the Environment and Transportation Committee, but when the bill made it over here, I gather there was concern that, that we have enough speed cameras already, and if a speed limit goes down from 30 or 25 to 15, or we we going to have a whole new proliferation of cameras? And so this committee added an amendment to say that speed cameras could not then be added in places where the speed limit was dropped as low as 15. That would not be an additional opportunity to also put in speed cameras. I don't know if the chair remembers this, he's nodding his head, but that's where that amendment was put in.
That's right.
No, I guess my question is, if we did this last year and we allowed Montgomery County to do it, I'm just wondering, what has Montgomery County done? I mean, I have no issue with, if Montgomery County came in and said that they wanted to do whatever they wanted to do, that's fine. I'm not certain, I'm trying to figure out now, how does this affect my county? So the only way I would know how it affects my county is what happened in Montgomery County. How have they used this power?
Senator.
So it's authorizing legislation?
That's right.
Your county does not have to take this up at all,
I
but certainly
understand
if
that,
it does, it
but
will have to hold public hearings.
So
and get
Senator,
public
Senator, I'll just say, so I think I was a sponsor of the bill last year, so I cross-filed with Delegate Moon. And so our county council asked for that authority.
Right, and what you're saying, which is why I'm asking.
Correct.
I know my county hasn't asked for this, and I don't know if I have issues with my county.
No, I understand.
council,
No. So the answer to your question, I'm not quite sure how it's been implemented, because it was only last year. So I know our county asked for it, so there were a couple of neighborhoods that had some serious pedestrian fatalities, and so some of the local jurisdictions wanted to have the ability to lower the speed limit below 25. So that's
Mr.
what.
Chairman, if I might, there was no opposition to the bill. There were a few pedestrian and bicycle advocacy groups that testified favorable with amendment because they were concerned about not having the ability to add speed cameras in these lower speed limit areas. That was their only objection, but we heard no other opposition. And that was not opposition, it was favorable with amendment.
Thank you, Delegate Lehman. Just a question, where am I at? On page 2, and I'm looking at lines 22 to 25, and I'm just trying to think this applies. You know, in Prince George's County, we've been working on our P3 initiatives to simultaneously build several schools, and we're working on our second round now. If we build a new school in a new area, and the speed limit in front of that school is on a highway 25 miles per hour or maybe less, does this restrict the county from putting a speed camera there to ensure enforcement in that school area?
Are you thinking of a specific situation, Senator?
I'm speaking of the tract of land that goes in front of almost every school.
Mm-hmm.
There's usually some kind of traffic calming device or
Right.
posted, got to slow down. We're building new schools now that, depending on where we put them in the county, would theoretically not, the speed limit would have to be determined, right? So would this bill restrict us from being able to put a speed camera in that piece of, that road that goes in front of a school if the speed limit is less than 25 miles per hour?
Yes, based on the amendment from last year that we are keeping intact, I think it would have to be one or the other. And I guess, departments of public works and police would have to look at whether it would make more sense to have the higher speed limit with a speed camera, greater than 25, or to lower it to 15 and go without the camera. It would be an either or, but you
Okay.
can't have both.
Okay, thank you very much.
Thank you for the question.
Yeah, just to be clear, you could, if there's a speed camera currently installed, and the speed limit's 30 or 40 with a speed camera, you could take it down to 15 miles an hour for those grandfathered in speed cameras, right?
If an engineering study warrants, and after public input, it could be lowered, but then it precludes the opportunity to have a speed camera. And that includes, even if there was a speed camera already there, if the speed limit is dropped to 15, that speed camera would have to go away unless we revisit this law in another, assuming it passes, if we revisit in another year or two. But right now, it says you can't have a speed camera.
But that's not what the law says. The bill says the local authority may not implement a new speed monitoring system at less than 25, which means that.
Can you tell me where you are exactly?
Page 2 of the bill, line 22. A local authority may implement a new speed monitoring system. So if it's not if you've already got one there, then this doesn't apply. The whole less than 25 miles per hour provision does not apply. You're not implementing a new one.
Right, and
You're just-
are you concerned that it's only applying to new rather than if there was one there, that this is an inadvertent, like loophole, or?
Oh, it's a great big hole, but, yeah, okay. Just saying, that's not, thank you.
I can follow up if that's still not clear, Mr. Chairman.
Yeah, so we had a bill in here from Baltimore City, it was Senator Washington's bill, and I think part of it was city-centric, but the other part with the cameras, without a study, either existing or new, could not be done without the traffic study. So does that?
Came in like this, and
Yeah.
kind of modified to say, use a camera. So
Yeah,
you
so
can't
if
use
her
it.
bill goes into effect, then I think
Then, because that's without a study.
Yeah.
This requires a study.
to put in a new one. But what about the existing study? What about the existing camera?
With this as drafted, you could keep using it.
Got
If we
it.
made the same change to this bill, you could have the same effect.
Got it. Okay. Senator West.
Thank you, Mr. Chair. Sorry for a second bite of the apple, but why does the General Assembly, why are we going to be passing state laws to tell a local county what the speed limit is going to be on local roads? I noticed in the existing law, Calvert County may decrease the maximum speed to not less than 15 miles an hour on Lower Road. Why are we doing this? Why don't we let the counties determine their own speed limits? Do you have any idea?
They can, under current law, that was obviously a local law that got passed.
I'm sure it was.
At the state level, though, Senator, under current law, speed limits on roadways cannot be lower than 25 without the state giving local jurisdictions, counties, and in the case of the Montgomery law last year, it was also extended to municipalities to lower it to as low as 15, but not lower on roads. We're not talking parking lots or specific kinds of roadways, rural or otherwise, but to lower it after an engineering study. Otherwise, they cannot do that unless we pass a bunch of local, county-only bills. But the position of pedestrian advocates, and I share it, is that if this is good enough for one county to have that ability, then it should be good enough for the rest of the state to
No,
save lives.
I absolutely agree. But earlier this year, we got a number of bills on speed cameras on local roads. And we sort of said, no, we're not going to deal with this. We're not going to pass another state law every time some community wants a speed camera on their road. And I sort of feel the same way about this. Why don't we just give the local counties the right to regulate the speed on their roads, either through the county commissioners or through the county council and the county executive? Why should the General Assembly be passing laws about local speed limits?
So, and I appreciate the question, but my understanding is that that is certainly one approach, that is a philosophy, but they would still have to come to the Maryland General Assembly to be able to do that. County councils and county commissions cannot lower speed limits on roadways to 15 miles per hour under current state law.
Would you have a problem if we amended this bill, use this as a vehicle to say that counties can decide to set their own speed limit?
Well, that is what is the intent of this by being authorizing legislation. They don't have to touch this at all. All or most or half the counties in the state can say, we don't think there's a rationale for any roadway having a speed limit less than 25. Between that and speed cameras, we think people are safe enough. The point is pedestrian fatalities have gone up in recent years nationwide, even with fewer cars on the road. There have been all kinds of studies and reports. There was an article within the last month in the New York Times about the irony of fewer cars on the road, yet more aggressive driving.
Yeah.
And more
My
fatalities.
point is, in Montgomery County, the people of Montgomery County, through their elected representatives at the county level, may have different ideas about what the speed limit should be than the people in Garrett County, for example. So why shouldn't Garrett County be able to decide its own speed limits and Montgomery County decide its speed limits? And maybe use this bill as a vehicle to accomplish that.
Well, respectfully, it took the Montgomery delegation 3 years to get this bill passed just for Montgomery. So that process, county by county, could take years and years and years while we continue to experience traffic fatalities.
Okay, great, thanks.
Thank you.
Maybe you could amend something for golf carts as well, Senator West. So check out section 21801.1 on transportation article. You might have some ideas there. All right, additional questions. Seeing none, thank you very much. That'll end the hearing for House Bill 404. We'll now go to House Bill 713.
Thank you, Mr. Chairman. And again, for the record, I'm Delegate Mary Lehman. Good afternoon, Mr. Chair, Mr. Vice Chair, and esteemed committee members. I am asking your favorable report for House Bill 713. This bill would require helmets for equestrians under the age of 18 who are riding on public trails and other public property. The bill requires an adult who is present and directly supervising a minor or minors to ensure youth are wearing properly fitted and secured helmets that meet national headgear safety standards. Equestrian injuries are primarily the result of falls, and falling from a horse is not an uncommon occurrence. The goal of this bill is to protect young equestrians from getting a concussion or other serious brain or head injury by requiring helmet use. The last several years have seen substantial increases in media and other reports related to concussion safety in sports. And a concussion, of course, is a brain injury caused by a bump or a blow to the head that can actually change the way the brain operates. And even what seems to be a mild bump on the head at the time can turn out to be quite serious. I want to be clear, there is no such thing as a concussion-proof helmet. However, an equestrian helmet that meets or exceeds safety standards of the American Society of Testing and Materials for protective headgear used in equestrian riding can certainly help protect minors. There are some exemptions in the bill. HB 713 only applies to minors riding horses on highways, public riding paths, or other public property. The bill does not apply to youth who are practicing for or competing in those events where helmets are not worn, and those who are engaged in agricultural activities or pursuits. The adult who is present and directly supervising the minor may be charged with a violation. The minor will not be cited. And so the penalty in this bill is the default penalty under the Transportation Article 27101. A prepay amount would be set by the District Court of Maryland. That's usually in the $70 to $100 range, and this would be a misdemeanor. And of course, the person who receives the citation could go to court just as you could with a traffic violation. The use of an equestrian helmet should be as commonplace, I think, as seatbelts, and like laws that require kids to wear bike helmets or sit in booster seats in the rear of a car to safeguard them in an accident. This bill will help safeguard young equestrians from head trauma and serious injuries as a result of a fall. Protecting our kids from avoidable injuries should be everyone's concern. Mr. Chairman, the trail riders of today, the Maryland Horse Council, and the Brain Injury Association of Maryland are all in support of this bill. There was no opposition, and I urge your favorable report.
So, hello, and Delegate, happy to see you here today.
It's good to see you as well, Senator.
What is the definition of horse riding?
What is the definition?
Yes.
Meaning whether we're talking about horses or ponies or other, what do you mean? I'm not sure what you're asking.
So does this definition apply to just people that are sitting on an animal, or are they driving an animal? Are they in a car?
No, actually riding on the back of a horse, on public property only. It is not applicable to private property. So trails, highways, in the case where that is allowed, and that is already limited somewhat under Maryland law, and public parks and other public lands.
So my question is, when I look at the transportation article, it says every person riding an animal or driving an animal-drawn vehicle on a roadway. And the reason I bring this up is many of my colleagues here get to see, I'm going to have the fortunate situation of having 3,000 Amish people, right? And horse and buggy is definitely a main mode of transportation in my northern end of St. Mary's and Charles County by them on public roads. And I just wanted to make sure to see whether or not we were going to require them to put helmets on every time they got in a buggy or every time they got on a horse, anytime they were moving from one farm to the next with farm machinery, whatever.
So Senator, thank you for raising that question, and I had a feeling you might raise that because of some of our other conversations about your constituency, your Amish constituency. So in current law, it is meant to be people directly on horses, not a horse and buggy situation. But in existing law, and you probably know this, it says, except in Charles, St. Mary's, and Worcester counties, a person may not ride an animal or drive an animal-driven vehicle on any divided highway where the posted speed limit is greater than 35, or on other controlled access highways. And then there's another law specific to Anne Arundel where a person may not ride an animal on any part of a highway, so at all, helmet or no helmet. If you need further clarification, or your reading of this is that it's meant to apply to people driving horse-driven carriages or carts, if that's your concern, or are you talking about individual constituents of yours, Amish constituents that might be on a horse?
So there's no doubt. I definitely would like to follow up about this because I don't see where they are exempted at all from this. Because the transportation article clearly says riding or driving.
And they could possibly be covered. This was an amendment that the ENT Motor Vehicle Subcommittee came up with to say that it does not apply to those who are either engaged in agricultural pursuits, which would be one part of your concern, but also for, there is language around practicing for or competing in events where helmets are not traditionally worn, and that has to do with people who ride Western style. But if you would like to work with me, and I'm open to that, to address it in a way that we're sure that it does not apply to the Amish, I am happy to do that.
And so I had
Thank
another.
you for the question.
I had another question involving, I noticed that this says on public property. And we have had great debate in the Senate this year on liability of landowners on their own private property when it comes to activities such as hunting and things like that. Why does this not involve private property? If we're going to require somebody to ride a helmet on public property, why wouldn't we require it for the liability of those landowners so that somebody doesn't use a helmet on private property?
So that's a valid question. First of all, we anticipated there would be a lot more opposition, frankly, but we were also told, for example, when a colleague in the House wanted an exemption for pony rides at like local carnivals or fairs or school events, and we called around to some of these companies that bring horses, more often ponies to special events, their response was, we have to do this for insurance reasons anyway. Now, with absent a law, we do offer parents the opportunity to sign a waiver to say if my child does fall and gets hurt, we cannot be held responsible. And the one company that my intern, Charles here, talked to said, you know, it would be foolish of us not to provide helmets, but there are parents that, you know, for concerns about, you know, lice and other things, just aren't comfortable putting a helmet on their kid. But if we pass this law, there would not be that ability to sign a waiver.
Okay, thank you.
Yeah, would this include for like at fairs or carnivals, you have these little pony rides where somebody walking the little pony around, the kid has to wear a helmet for that too?
So thank you for the question. Yes, if it's on public land. So for example, my neighborhood elementary school has a carnival every year where a private company is contracted and brings ponies, but that is occurring at a public school. And so it would apply there. If a child, you know, or an adult has a birthday party or other private event and horses are brought there, even if it's a rental situation, pony rides on private property, it would not apply.
It just strikes me, I mean, that's one thing if you're riding a horse out galloping. Another thing if you've got a kid on a pony and they walk the pony around. I'm not sure how many accidents happen on that, but what was the accident statistics that's driving this? What are the statistics in Maryland? And I apologize because I came in the middle of your testimony.
No, that's a good question. The Maryland Brain Injury Association testified at the House hearing and had some of those numbers. I don't have them in front of me, but I'd be happy to follow up.
Yeah, I mean, before I like to do any new restriction or law, I actually like to know what the problem is we're solving. And, I mean, just to be honest, the pony ride one is, I don't think we need a helmet, but if kids are out galloping, it just seems like that's something that parents and other people, I mean, did people... I guess you get analogies and stuff, but no, there wasn't real statistical evidence that came in, people coming in the committee and saying there were lots of problems?
I'm sorry, so
Did you have people come in the committee and testify that there were lots of problems and fatalities in Maryland?
This bill was actually requested of me by a constituent who, my neighborhood backs up to WSSC property, several thousand acres, and people ride horses all around those trails, and she always wears a helmet. This is a 60-something-year-old woman, but she was concerned by how many kids she saw on the trails without helmets and said, why isn't this a law? We require children to wear bicycle helmets. Why isn't this a law? And it does apply only to minors. It's not for adults
I
under
understand
age
that,
18.
but I've always believed that, I guess it's a mindset that a lot of people don't share, is that if we're creating a law or doing it, there should be a problem. And I guess my question is, outside of a constituent that didn't like the way that somebody else parented their kid, did people come in and they testified and they said, oh yeah, this is a major problem. In Maryland, there were 100 fatalities last year. I guess that's what I'm trying to get at. Did individuals come forward and testify that there were actually fatalities and serious accidents?
I understand that. It's considered a preventive measure. Again, I would just say there was no opposition, and there was support by the Maryland Horse Council and Trot, which is the trail riders of today. There was no opposition at all.
Okay, thanks.
Just had a question on page 2, lines 19 through 21. This particular exemption, would you mind, I thought I heard earlier you said something about Western something or other. Could you explain this
I'm sorry,
exemption?
page 2, what line?
19 through 21. Practicing or competing or performing in a show or event where helmets are not historically part of the show or event?
So you're asking why that riding to or from was struck?
No, I'm trying to understand what is it that we're talking about there? And I mean,
Oh,
and I'm
this
just
is
wondering
for-
why they're being exempted.
Right, thank you for asking that. Western riders and others who are doing ceremonial type riding, probably not so much in our area, but this might be a reference to, it could be a reference to like rodeos and that kind of thing. But mostly Western style riding, where they would object very strongly. I don't know if some of you are familiar with that. I myself am not an equestrian, but one of my delegate colleagues who is advised me on this, and she is on the subcommittee, and said we should not touch that.
But it would seem to me, if you're involved in those types of activities, if you're worried about injury and stuff, injury is likely to happen there. So I'm just trying to understand why and make one group of people, riders, wear helmets and this one not.
This is, with Western riding, that is a history that goes, really far back, and we're trying to be,
And what is Western riding?
respectful of that.
I don't know. What is Western riding?
It's different than, Eastern. I don't know. Senator.
That was the
There is
best
a senator
answer
who might
provided
know
in
better than me.
JPR
I don't
the
know the
entire year.
difference.
That was the best, that's the best one. That's good. It's good. It's the old English.
Cowboys,
Yes.
that kind
No,
of,
no.
that's what I'm trying to understand.
No,
I'm like, what is-
but I don't know the actual
Very good. No, that's
difference,
fine.
and I will follow up, I promise.
Charles, getting him. All right. Yeah. It's our first equestrian bill this year, right?
No, I
Yeah.
appreciate all the horsing around. I will certainly do whatever follow-up is necessary.
Senator West, no horse bills next year, though. No horse bills next year, Senator West. All right. All right. Senator West.
When we vote on this bill, you're going to hear a lot of nays.
I hope not. I think this bill has been introduced 2 or 3 times before,
That was a
Mr.
pretty
Chairman.
sick burn there.
This bill has been introduced a few times before
burn.
and never passed the House, so I appreciate your favorable consideration.
Oh, God. Oh, man. All right. Well, this has been enlightening and entertaining. We'll keep trotting. All right. Thank you very much. That'll conclude
Thank
the
you, everyone.
hearing for House Bill 713. We'll next hear from Delegate Stein with House Bill 1066.
Thank you, Mr. Chairman, Mr. Vice Chairman, and committee members. This doesn't deal with any live animals. It just deals with vehicles, and specifically vehicles used by the fire police. And the fire police are fire department members who typically will go to the scene of an accident or an emergency and help with traffic control or looking for lost individuals. Right now, the vehicles that are used by the fire police can only have red lights on them. This bill would authorize them to have white lights. The feeling on behalf of individuals with the fire police is that having red lights at the scene, only red lights at the scene, I'm sorry, I may have misspoke. This bill authorizes the use of white lights. Right now, they just are authorized to use red lights, and there's a feeling that that can blend in with the scene. By allowing the use of white lights, the feeling is that there will be a better margin of safety. The Maryland Fire EMS Coalition supports this bill, and Joel Mccray with MSFA is here to answer any questions. And I'd be happy to answer any questions as well.
And good afternoon. We had a bill a few weeks ago where we gave another set of emergency vehicles the ability to use, I think it was a blue light? Was it blue or green? Oh, and okay. And I'm just wondering if, we have red, all right, so it says red lights or red and white lights. Your expert is?
Yeah, I believe that deals with traffic accidents, but, and
So it
not.
wouldn't be applicable to?
They're different situations,
Okay.
but maybe if you don't mind, could I ask
Yeah,
Mr. McCray
please,
if I'm
I'm
correct?
curious.
Am I correct on that, Joel?
Good afternoon.
Good
For
afternoon.
the record, I'm Joel Mccray, President of the Maryland State Firefighters Association. Any questions, sir?
Yeah, I was just wondering about the lights. I mean, and the distinction with the red and white and whatever it was, whatever colors were that we had supported a few weeks ago. I'm assuming the purpose of this is so that these particular vehicles stand out from the rest?
That's correct, sir. Currently, fire police do have red lights on their vehicles. They cannot use them en route. They can only use them on the scene.
Okay.
And they are asking to be able to use red and white lights to make them more visible at the scene. We use them a lot to help direct traffic, and we'd like them to be as visible as possible on the scene.
Do you know anything about the other colored lights?
I do not know, sir.
Okay, thank you.
Just a clarification, thank you for coming today. You said, so this is only for use at the scene. When I first read the bill, I thought that there were circumstances where a firefighter is driving in their own POV and they get a call and need to assist and need the lights to help speed through traffic to get to the scene. Is that inaccurate, or is this?
No, sir. There is a provision for certain individuals of a fire company, the chief or assistant chief or an EMS vehicle, to be able to use the lights en route.
On their own POV? On their own personal vehicle?
Yes, that's
Okay.
correct.
Okay.
But there's two different scenarios going on. One is for the emergency personnel or the chiefs to be able to use them. And the other is for the fire police who come and help us direct traffic, and they can only use them while on the scene.
I understand. Thank you.
Yes.
All right, seeing no further questions, thank you, and thank you, Delegate Stein, thank you.
Thank you.
Thank you.
And Mr. Chairman, if I could just follow up.
Yes.
Senator Sitter, I'm happy to research that other bill that you're referring to, but, okay. Okay, thank you very much.
Excellent, thank you, good to see you. All right, next we'll have Delegate Bartlett, welcome, with House Bill 1323.
Thank you, Mr. Chair. It's good to be here. Thank you. Mr. Chair, Vice Chair Wall-Striker, and members of the Judicial Proceedings Committee. For the record, I am Sandy Bartlett, delegate from Anne Arundel County, District 32, and it is my pleasure to bring to you an easy lift. House Bill 1323 is a corrective bill to fix the incorrect cross-reference of a provision in the law that requires a physician or hospital to provide certain healthcare services free of charge to a victim of sexual abuse. The change does not directly affect governmental finances and is not substantive. A healthcare provider is allowed to be reimbursed for providing those services I just mentioned. The problem that has come up, however, is with the incorrect cross-reference is the administration of that reimbursement. When we switched in 2018 from the Maryland Department of Health to the Victim Services Unit in the Governor's Office of Crime Prevention, Youth and Victim Services, concerning various eligible expenses for cases involving rape, sexual offenses, or child sexual abuse, with oversight functions and operations relating to the Criminal Injuries Compensation Board, we repealed the Health General Article, Section 15-127. But the cross-reference to this repealed section of the health article remains in the Criminal Procedure Code. House Bill 1323 amends the code by deleting the incorrect cross-reference and citing to the correct section, Section 11-1007 of the Criminal Code. As I said, House Bill 1323 is an easy lift. The bill passed unanimously in the House, and for the reasons stated, I request a favorable vote on House Bill 1323 to facilitate this important correction. Thank you, and if you have any questions, I'm here.
Thank you, Mr. Chair. Actually, I don't have a correction, but I thought we've passed legislation in the past which gives the people who put these bills into the code the authority to make technical corrections as they're doing that. So do we really need a separate piece of legislation to correct a cross-reference?
We do.
We do?
We do.
Okay, well, I'm in favor of it.
Thank you.
Code to do that, otherwise it can be done in the corrective bill.
Got it. Yeah. So do you remember Senator Kagan asked the question on the Vital bill with the mufflers and the racing events? And she asked a question about Section 4 on page 6, and it gave the ability for auto correction when there are multiple changes in definition throughout the code. So you could do something like that, but that was a weird feature. It was a unique feature that is not commonly used, but sometimes used in these rare cases. So maybe you could do something like that. But yeah. Okay. Thank you very much.
Thank you,
Thanks.
Mr.
Good
Chair.
to see you.
Bye-bye.
And with that, that'll conclude the hearing for House Bill 1323. We'll now move on to House Bill 877, and we have Andrew Tress to present for the department. Welcome.
Thank you, Mr. Chair, members of the committee. For the record, my name is Andrew Tress, Legislative Director for the Department of Juvenile Services, and I'm here in support of House Bill 877 as amended. This departmental bill would bring Maryland into compliance with the Federal Juvenile Justice Delinquency Prevention Act, and what that means is all youth under the age of 18 would be removed from adult jails and placed in juvenile detention facilities while pending trial. Now, the reason this is emergency legislation is because if the state does not come into compliance, we risk losing potentially up to $370,000 a year in federal grants that go to community-based initiatives, diversion programs, youth public safety strategies, et cetera. Additionally, this bill does not have a significant impact to the department's operations, and DJS is already equipped to supervise this population and accommodates the majority of youth charged adults in juvenile detention today. In fact, DJS has done so since 2015 when this legislature authorized youth to be held, transfer-eligible youth to be held in juvenile facilities rather than adult jails. And currently, the youth charged adult make up about 60% of juvenile detention population. And DJS is by design better suited to serve this population than our counterparts in the adult system. There were amendments to the bill. One allows the department to focus on bringing jurisdictions around the state into compliance immediately. The Youth Detention Center of Baltimore City already has sight and sound separation for this adult population, and therefore they're already compliant. Another prohibits jails from using seclusion or isolation in order to maintain sight and sound separation. And also, I believe MACO has an additional amendment which would eliminate the exception allowing some youth to be held in adult detention after a bail review because of challenges maintaining that sight and sound separation. DGS does not object to these changes. And finally, this committee passed a very similar bill unanimously last year. For all these reasons, I urge a favorable report. Happy to answer any questions.
Yeah, so you answered my first question, which I thought we did this bill last year or
Yeah,
something.
it was,
Was it identical or is it very similar or what?
one of the biggest provisions that was actually removed was a provision that would have allowed the adult, use charged adult population to go on community detention, electronic monitoring, been removed. That was really the biggest, most substantial piece.
Okay, and then I guess you have the bill in front of you, right?
Yeah.
Just want to go, page 6, or at least this version of it, line 20, talks about compliance with revisions may not be achieved through seclusion or isolation. Are those defined? Do we know what those mean, seclusion and isolation?
I'd have to look it up. I know the majority of a lot of this language, since it is a federal compliance bill, was taken from the actual Juvenile Justice and Delinquency Prevention Act. So I'd have to look back to find the exact definitions of them. But through the consistency of the use, again, I don't want to assume anything. I can follow up to be sure, but.
Yeah. And I say that because you could either do a whole new facility for juveniles, or you could say, I have this jail and this wing over here would be just for juveniles, but does that mean seclusion or isolation? Do you have to have a whole new building?
It could, and that's part of the amendment for MACO. Some facilities have logistical difficulties doing that, so sort of taking some of that exception away sort of reduces that.
Is the MACO, I'm sorry.
I actually haven't seen the amendment, just this is through
All right.
conversations.
So that's there, all right.
Yeah, yeah.
And then my other question is, I see, it says it's emergency legislation. Is there a reason? I mean, obviously, people who can comply who are already ready can comply right now, but this is going to be, what?
Well,
I see
again,
Baltimore
sort
City
of-
as an exception until October 2022.
Right.
So why would not, if this was not emergency legislation, isn't that about when it would normally become effective? And why not just let everybody become effective then?
Well, sort of emergency, at part one, like you had said, it was in here last year, so it was sort of, the compliance actually was, I believe the end of 2021 was when states have the ability to become compliant, right? We try to, become compliant without legislation as much as we can, and we haven't received any notification or lost any money to this point, but that's one of the reasons why it's emergency. And also, so like the Baltimore City Youth Detention Center, they're already separated from the adult population. So they maintain that, so that's why they got sort of the staggered implementation. However, the other detention centers around the state don't always have that. Kind of like you were saying before with the separate wing, not a lot of detention centers have that. So this would allow them to come in compliance immediately.
Okay, well, maybe I'm misunderstanding. This, the exception for Baltimore City looks like they're giving them more time, but you're saying, but they're already compliant, so why would we give them more time if they're already compliant?
Just to push the immediacy of getting all the other counties into compliance. Again, it's just about meeting the federal standard. So more youths are going to be coming from Baltimore City. They already have the sight and sound separation. Therefore, the rest of the state is being prioritized in order to move those youth immediately. I hope that answers your question.
No, not making any sense to me at all, because if they're already compliant, why would we give them more time if they're already compliant? What I see you just saying is, I hear you saying they're already compliant, let's give them more time. Why do we mention that in here if they're already compliant?
I'm sorry, I don't know how to answer I don't think I understand your question entirely. It's
I'm
just
looking
I
on
understand that
page.
they're more compliant.
Page 7, lines 20, 21, it says that Baltimore City is not required to comply with this provision of this act until October 1, 2022, which would suggest to me that they're getting more time. Why would I give you more time if you're already compliant?
Just to meet the federal mandate, right? The whole state has to come into compliance.
Right.
We're prioritizing every other county because they don't have other facilities that can meet, and while it is a youth detention center, they can get better services under under our facilities. So we still want those kids, but the other counties that don't have separate facilities, we want to bring them up to speed quicker.
Okay, yes, that's all right. We're going in circles here, but we'll figure it out. Thank you.
Seeing no further questions, thank you very much.
Yeah, thank you.
Excellent. All right, that'll conclude the hearing for House Bill 877 and our bill hearings for the day. Let's take a half an hour, and then we'll come back, we'll vote on a short list, and then there will be no voting on Friday, tomorrow, so. All right.